for the zoning interpretation located at 139 Caracas Drive. If the representative can come on up.
Good evening. Thank you for allowing me to speak. This matter, as the chair suggested, was on at the last month's for consideration. It was adjourned and tabled so that we could do some additional exploration on the issue of the statute of limitations. As the Zoning Board of Appeals is probably aware, the code provides that appeals must be submitted within 60 days, quote, after the filing of any order, requirement, decision, interpretation, or determination of the code enforcement officer. It was suggested at the last meeting that the board might want to consider the possibility that Mr. Artuso's announcement that the town board would be considering sending to the planning board an application that was for solar panel development that was to be treated under an industrial use permit only. That does not raise statute of limitations issues for three different reasons. First, that announcement was a fallacy. It was a nullity. There was no application in Mr. Artuso's possession. There was no application before the board. So there's nothing in the announcement that was correct. Now, secondly, because there was no application before Mr. Artuso or before this board, there wasn't an application that I could review either. Now, if I'm to challenge the propriety of any application, I have to be able to read it. Otherwise, I mean, the application could have been treated perfectly legitimately and appropriately. I wouldn't know until I read it. And if you're going to start the clock before I have the ability to read an application because we don't even have one, then Mr. Artuso is unlawfully shortening my client's statute of limitations. Simply can't do that. Thirdly, nothing in an announcement of a public meeting of the town board constitutes the filing of a decision or an order of the law enforcement officer. As Mr. DeMarco suggested at the last meeting, there's nothing in the town's procedures that technically satisfy that requirement. And I have used, and I've urged the board to consider, an email that was sent by Mr. Artuso back on April 1st. The only reason I did that is because it does explain his rationale for treating it as an industrial use application. And we did file our appeal within 60 days of that. So if we're using that as a starting point, then we've satisfied the statute. But in truth and in fact, the clock hasn't even started running because that also does not constitute the filing of a decision in order relative to his decision. It was simply an internal email. So unless the board has some questions with respect to the statute of limitations issue that was brought up at the last meeting, I'd be happy to very briefly review the merits of our appeal.
So I guess thank you for that. I guess ultimately the question to the board is ultimately an interpretation of the zoning, right? That was really the first point that came to this board. At the last meeting, there was question of timing and if it could even if it even should be here in front of us. I think honestly, the board has the ability to take a look at and make a determination on the merit of the interpretation and what was interpreted by the town. I know I had an opportunity to go through documentations, and though the document that was presented on April has some clarity, so do other documents. I would say, in my opinion, there's no smoking documentation that provides an earlier date. So from my opinion, I think it'd be more prudent for this board to move forward with making a determination on the merit versus determining the timing of everything. I guess I want to hear from everybody else what your thoughts were, if you had chances to review the documents and if you feel differently.
I tend to agree with you. I do just want to make a point of clarification, because I did pull up the document that we had discussed was the resolution made by the town board and the July 2025 town board meeting. Mm-hmm. There was actually an application submitted, so I just want to correct for the record, or make sure the facts are out there for the record, that when I pull it up right now from the town's website, there is a June 30th application from Montante Solar that was part of what was on the town website for the entire town of Webster and anybody else that cares to look at. And it appears very similar to the information that you had also provided that was an amended application from August.
Respectful.
So there is something that was there. It's not like the town board acted based on nothing.
Thank you for the clarification. The town board had a partial application that did not even include a site plan. So incomplete was the material that was submitted to the town board, that the town supervisor was not even aware that it was being placed on top of a hazardous waste site. He thought, and this is in the record, when he referred it to the planning board, that it was being built in a field somewhere. They had a very brief skeleton of an application, nothing nearly even approaching legal sufficiency for an application.
Typically, and I could be incorrect, but typically I believe at the beginning stage of a project, this would be the information received. And granted, I'm just doing it from my engineering perspective, from an entirely different industry. But the application that's here is a rough site plan with the recommendation to send it to the planning board, which is what any project would do within the town of Webster. And then the details are filled in before anything is finalized. Final plans typically are not the first, and I could be speaking out of turn.
Well, for a project this
But
size,
for a
they're
project
not.
of this size, the first plan you see is not the plan you end up with. You start with, this is what I'd like to do, and then you fine tune it. The information I'm looking at, and granted, I'm just pulling it up today from your comments, has rough dimensions. It has the rough layout of the solar field. It has a short application. There's information here that's too small for me to want to read on my phone, but there's several pages, so it's not no information. It's preliminary information. It probably I would have to read
And the
it.
town board accepted it as an application, I guess was the question. Was this
Right.
just, hey, can we come by and talk about it? Or was an application made,
Yeah.
form work filled out? And
It's a formal.
It's a formal,
Yeah,
it's a
that's what
formal
I'm saying.
application.
That's what I'm saying. So it's a formal application. So the fact that it isn't ready to be built based on the information there doesn't lessen the fact that an application was made.
Sure.
I mean,
And it doesn't change the direction that the board is going to go with, but I just want to clarify that it's not as though the town board acted in total darkness,
Thank you.
based on the documentation, at least, that's available to me.
Yeah. Yeah, I mean, and that's what I saw as well, right? There was documentation out there. It's not, things aren't being hidden from the public. It's out there. And the process is playing out as it should. So, thank you. Any other questions? Like I said, I think moving forward with the basis of merit whether the town presented this project appropriately. Because right now, the town, the site is an industrial site. The town looked at this. They looked at zoning code 155-6, which is the approval standards for a large-scale solar energy system. And a large-scale solar, and it states, large-scale solar energy systems are permitted through the issuance of a special use permit within all residential districts. The site in question is not an industrial district. So I guess my question to the board is, does anybody feel that this needed a special use permit? And the way I look at this, based on 155-6, a special use permit was not required.
I would agree with, but I came to the same conclusion.
May I address the board on that point?
Hold on.
You misstated your words. In terms of, you said that it wasn't an industrial district, unless I included.
The site that it is on is an industrial district.
Correct.
So if I misstated it, that's not what I meant to say. Other questions? I mean, I don't know if
I
anybody
concur
else.
with what you've said.
Okay. Mr. Hanna, you want to make a comment?
Yes, before the board makes up its mind on that point, the board really has to consider how the state courts require zoning boards of appeals to view the zoning code. And you have to understand, and I apologize, you're at something of a disadvantage because, and I'd encourage you to turn to Mr. DeMarco for assistance, but there are laws of statutory construction and interpretation, and you need to sort of understand that to understand how the courts are going to view this thing. First, specific language in the statutory code always trumps general language. And in this situation, we have two potentially applicable provisions of the code. One is industrial use, doesn't say anything about solar panels. It says something about public utilities, but for reasons I won't go into it, this doesn't qualify as a public utility. There isn't any question about that. So we have an industrial use section that says nothing about solar panel developments, and we have a residential section, a solar law section that applies to residences that is very, very specific about the development of solar farms. And it gives a whole bunch of criteria that have to be met. Now, the courts have been very, very consistent in making sure that the zoning boards of appeal view the zoning code as a whole. So even if there's specific language that applies to a residential district that is not contained in the industrial zone, if the industrial zone impacts a residential area, then you need to look to the more specific language. That is a matter of statutory construction that state courts simply require. And for special use permits, we look to guidance for in the Webster Town Code. And it says that they should be used for uses having some special impact or uniqueness, which requires careful review of their location, design, configuration, and special impact to determine against fixed prescribed standards the desirability of permitting their establishment on any given site. There are uses which may or may not be appropriate in a particular location depending upon a weighing in each case of the need and benefit against the local impact and effect. That's what the Webster Town Code says, and if that's not the appropriate criteria for a special use permit, I don't know what is. And it's not just my opinion.
So
One second though. It's not just my opinion. Montante, when they submitted the application, in the letter I showed you, specifically said that they were applying for a special use permit. They recognized that a special use permit is and was required. Not just me, the developer did as well.
thank you.
This fan has been running for 3 weeks straight. My bedroom is still 91 degrees at night, and my power bill is $340 a month. Now watch this. You plug this in, you press one button, give it 90 seconds, come back.
So I appreciate that. I know I've had the opportunity to go through the code. I've had the opportunity to take a look through the industrial code as well. Go on.
Mr. Hanna, can you, in support of that argument that you're making, the specific versus the general, what is it between the two statutes that you believe are in confliction with each other?
Well, for a special use permit, it requires that the planning board and the town board give a great deal of consideration to many factors that are not required in industrial use. For an industrial use permit, it gives a list of activities and says, okay, if the activity that's proposed is similar to that, it's fine. It's in an industrial area. We don't really need to worry about it. If it's a special use permit, there are a whole bunch of factors and considerations, some of which I just read, that have to be considered by the planning board, have to be considered by the town board, and they weren't. And Montante knew that those were questions that needed to be asked, that was information that needed to be provided, and that's why they acknowledged in writing to the town board and to the planning board that they needed a special use permit.
So but you agree that the zoning board would have to find, in order to agree with your specific versus general construction argument, that there is in fact a conflict between 350.22 and 155.6?
No, I don't think there's a conflict is required. I think that, as I said at the outset, more specific language, if you have specific language that's applicable and general language that's applicable to a given application, the specific language trumps the general language. So there doesn't have to be a conflict per se. There just has to be, the specific language has to fill holes that the general language does not.
I respectfully submit, I think that the argument that you're making is accurate when there is a conflict. And if they can be read in harmony with one another, then I think the board has the right to interpret it, obviously, as they deem it should be applicable. And so I think the board, I think you correctly stated the law when there's a conflict. If the board doesn't find a conflict and they can read both statutes in harmony with each other, then it can make a determination based upon the applicability of the statute, not that one excludes the other.
I respectfully suggest that the law provides that where one statute requires more, you have to give more. You have to meet the higher standard.
Okay.
But there's a second, I don't know if we want to vote one
I can
issue
say
at a
I'm not
time,
an
but there's
attorney and all the.
I'm sorry?
I'm not an attorney, and all the jargon going back and forth has got me got my head spinning a little bit, to be honest. I don't want to say I read things plainly. I looked at 155-6. I mean, that's pretty clear language that a special use permit is required in the residential district. It is silent on requiring a special use permit anywhere else. That's how I've read it. I've had the opportunity to go through, is it 350-22, which is industrial use as well. And again, certain sections in there lead me to believe that it's allowed within there. Is it explicit? It is not explicit, but the way I've read it, it's for me it's pretty clear. I guess with that, I'm going to open it up to the board with questions, and there's a lot of things going on within the code and everything else, and and back and forth. So questions from the board?
The only question I have is that if the applicant is concerned that certain things that might come out or be pertinent to the design and move the project forward, that they'd have a better chance of getting what they needed out of the application process. The planning board is most likely going to consider those issues anyhow. Anything that's required under a special permit, it's not like they're wearing blinders necessarily, because it's not a legal issue if planning board says, have you considered rotating the project or moving the driveway here or there? So my thought is that any of the applicant's concerns that somehow they're getting less of a review than they think they need or want, I don't know if I find that valid, because, like I said, the planning board would, I think, naturally look into all those items, whether or not they were tasked to by code. Did that make sense?
It did. Other questions and comments from the board?
Mr. Chairman, before there's, I'm sorry.
No?
I have one question for the applicant that I guess I'm assuming is a typo throughout the application, but I just want to make sure. Under most of your sections, you're referring to a section 151-1 for a section within the code that is not part of the current code. I could not find it historically.
I apologize.
And I'm assuming that that's just a typo, but I guess I just want to confirm that.
Probably so, I'm sorry.
Okay, so you're actually looking at, it should be 155-1 through 155-10.
Correct.
Okay.
Other questions from the board? No?
There-
No. not
No.
yet.
Mr. Hanna, you wanted to make one last comment?
Well, there's one more point that I'd like the board to consider
Okay.
with respect to the application. The classification, whether it should have been special use or industrial use, is only the first issue. The second issue is whether the town board approved the same project that the planning board approved, and it did not.
I don't think that's for this board, I don't think that's our,
Actually,
Yeah, that's accurate.
yeah, so,
The issue is the appeal of Mr. Artuzo's refusal or failure to put the other special use permit before the town board. And that, I think it stops there. You may be accurate in the point that you're trying to make, but I don't think that issue is before this board.
there are several issues that I've not raised before this board that are in fact in the Article 78, and they would be prosecuted there if necessary. However, I think that this board is entitled to determine whether the permits that had been approved or of the same project.
Well, I think that goes more to the arbitrary and capricious standard that the Supreme Court judge will look at. Our duties here in the appeal capacity that you're asking us to look at here relative to the notice and the recommendation, I don't think it goes further than that. Otherwise, we would really be stepping into the shoes of the Supreme Court. We don't get paid enough for that.
Well, maybe you do.
thank you.
Thank you.
Thank you. So, I guess I'm bringing it back to the board. Questions or any other dialogue after hearing everything that Mr. Hanna had presented, plus all the documentation that we have received over the last month or so. Any other questions? Anything else we want to discuss?
Well, let's be clear, we have Mr. Hanna's application, which is a notice of appeal and I believe a memoranda of law or the equivalent. I know all the board members have that.
Yep.
We have a series of documents that are entitled, I think it's a letter from Montante to Josh Artuso, or is that something that I have on this?
No, that was the additional.
That was the
handouts
additional
from last
information,
meeting.
Yeah.
Okay. And then the board has looked at the resolution from July of 2025.
Yes.
It has reviewed chapter 155, which is the energy chapter. It has reviewed the industrial, the
350-22, industrial.
correct
Zoning.
in 155.6 and the corresponding sections under the town code. Obviously, it's heard oral argument from Mr. Hanna. My comments, just want to make sure that the record's clear as to what you've all reviewed before you make any determinations. Anything else that I've left out?
Besides the application, the short, it's like EAF.
There's a set of prints with the application.
That's the one
Prints.
with there's photographs. and-
Yeah, yep.
Right.
Right.
Yeah. Okay.
I would encourage the board to address the merits of the application. You certainly have the right to make a determination as to whether the notice is timely. If you decided that it was not, you don't have to get to the merits. If you decide that it is, you get to the merits. I would only caution you that, when you look at the New York Town Law 267A, and it references that each decision made by an administrative official charged with enforcement of zoning laws, and it talks about filing, and then it goes into what constitutes notice. I think Mr. Hanna raises some colorable claims as to the ambiguity of whether that notice is sufficient. The very nature of notice in that context of a staff person, a municipality who doesn't have necessarily official orders, but is corresponding by email, memos of law, directives of the board, and whether or not that is sufficient notice.
It's a gray area.
It could be interpreted different ways by different folks. So I think it's dangerous. I'm not saying that you can't, but I'm saying I think it's fraught with the potential that it may come back to you.
And I guess that's the question. If, let's say we went down that road and said it wasn't timely, it goes before, I suspect it would go before the New York State Supreme Court. At that point, they could turn around, say it was timely, and kick it back to us anyway.
And come back to make a determination. So that's not a reason to not to do it, but that certainly is a reason why you may want it to consider if you feel you have a sufficient record and sufficient information and you're positioned to make a determination on the merits. I don't see any reason why you should not. If you want to short circuit it and wait for that order. If the order comes, you can put it off for another day. My sense of this is that based upon the record that exists now, I can't imagine that coming back around another day, you're going to have anything further to evaluate.
Yeah, so, I mean, again, with what I'm hearing, the gray area of the timeliness of it, of the notice, to me, it makes more sense to make a determination on the merit. I think we have more than enough information presented to us, both in writing as well as verbally by Mr. Hanna, to be able to make that determination. I guess I'm looking to the board to agree or disagree.
I think we've heard it a couple times now,
Mhm.
and depending on how much you may have individually looked into it, I think there's nothing that would be presented. Well, I should differently
Right.
that would be enough to move the meter at this point in time.
Fair enough.
Other than just like let's consider it based on the merits of the interpretation, and then see where it goes from there.
Does everybody agree with that?
Yes.
I do.
Okay. This is new to me, so is it just making a motion to make the interpretation as I see and let the board decide from there?
Just make sure you
Yes.
make it clear
I'll
which
do my best.
interpretation you're
Okay.
putting forth.
Okay. Let's see. So I make a motion for a zoning board interpretation regarding 139 Caracas Drive with a SBL number of 065-02-1-40-11. Whether the Xerox solar farm should have been reviewed under an industrial use permit or a special use permit in accordance with sections 155-6, sections 350-22, and section 350-101D1 of the Code of the Town of Webster. I make a motion that based on 155-6, which reads, oh, is it up here? Yep, thank you. A large-scale solar energy systems are permitted through the issuance of a special use permit within all residential districts. That plain language indicates that a large-scale solar energy system can be installed in the industrial use site without the special use permit application process. I think I covered. Nope.
I would
Hold.
just add the also known addresses.
Also known
We're
as.
being all legal here. 750 Phillips Road and 1460 Caracas Drive.
And we do not find any conflicting provisions of the code. So, sorry, say that one more time, Chris.
Just add the other addresses just to
The address is, okay,
750 Phillips Road and 1460.
1460 Caracas Drive.
Even though the SBL is the same,
Yep,
let's
all right.
be diligent about our,
Should I, do I need to restate that?
no.
Okay,
No, do we want to poll each board member for their comments or additions to it, or?
I'm good with that. You want to start?
Okay.
You ask.
Well, I just, I want it to be understood that every member of this board has considered this. There's been a lot of information before us. There's been a lot of sections of code, a lot of prints, and a lot of, it's not a decision that I think the board makes lightly, but based on the wording of the code with which the town is required to live within,
Bound by.
I don't see where we could come to any other conclusion. The industrial use is permitted with respect to looking at section 350-22. The process is very similar regardless of how it goes through. It goes to the town board, it goes to the planning board, it gets analyzed and revisited and rehashed, then goes back to the town board for approval. Based on how the solar code is written, I only see the special use permit required for residential uses. Large-scale solar in an industrial use is not deemed as specifically being required of a special use permit. And it does actually go into the next section that says that large-scale solar is permitted in commercial districts just simply by site plan review through the town board or the planning board. And it just has to comply with all setbacks.
Yep. Chris?
I agree with Corinne and would add that even though there might be a little more scrutiny given a special use permit based on a residential district, I have full faith in the planning board that they would have looked at any conditions required by the residential district for that and import them into their review and final decision-making process for it. I mean, that's what they're there for, and I think they do a generally good job of it.
Thank you. Mr. Artuso?
I agree with what's been said already. I don't know how I could repeat everything, but I don't think it's necessary.
In agreement also.
Can I get a motion? Vote?
I think we do this.
Oh,
We do it just in case.
yeah, okay. Before we move forward, if any public wants to speak for or against, please come on up.
Smell like you got some PTO from your BO. Escape the 24/7 freshness with Old Spice Fiji.
McDonald's is putting value back on the menu, which means make it a...
Good evening. My name is Jerry Bouchard. I live at 632 Pine Lakes Trail. And I have been to almost every meeting there has been regarding this solar project.
Can you please speak into the microphone?
I'm sorry.
Thank you.
Is that better?
Yes, thank you.
Okay. I heard a lot tonight and a lot of rationale and reasoning. The one thing I did not hear is how it is going to affect the people that live right on top of this project. And I have not heard the word toxic, which is what that industrial permit is allowing you to put a solar farm on toxic waste. My home is adjacent to that, and I won't suffer the consequences nearly as much as some of my friends back there. Some homes that are being built by a builder that's right now being built some of them are going to be about 200 feet from this solar panels. And they don't know that. Nobody has told them that. They do not know that. And you don't expect that the builder is going to tell them that. After all, he's out to sell homes. The problem I'm having here is, you probably know from my voice, I'm not from here. I'm from Long Island. I moved up here and had a custom home built on a beautiful piece of property. Was not aware that Xerox existed behind me and it was solar waste. It wasn't bad enough that I built a house there, but I think at that time there was surrounding farms all around there. The town went ahead and let a builder go ahead and build homes there. So close to toxic waste. I'm sure the builder didn't know that a solar project would be funded by New York State and no cost to Montante, no cost to anybody, but that the residents would suffer. There's a lot to be considered here. And I really, really hope that you take into consideration that a special use permit would have listened to my concerns. My concerns are, I don't want that in my backyard. 17 acres of trees are going to be cut down for this solar farm. I thought Webster was all about green space. That doesn't sound very green to me. We have lots and lots of wildlife back there that live back there. They're the only things that can live in toxic waste. And you're taking that part away from them and a lot from me. So when you consider this, make sure that you consider the people that live around it, just like you consider the people with the cell phone towers that are being subjected to this. I came here 8 years ago to Webster because it reminds me of back home. Back home has no elbow room. And now you folks are allowing these ridiculous things. And those solar panels are ridiculous where they're being put. Solar panels are great. I'm for clean energy. I think they're great, but not where you're putting it. Please consider the residents. Just this one time, consider us. Do the right thing and let it get shut back and do a real assessment on what this means to the residents there. Thank you for your time.
Thank you. Appreciate it. Anybody else want to speak for or against the project? No? Okay. I guess back to the board. Should I restate or what was already stated?
No, if the rest of the board
Agrees.
what you said 10 minutes ago.
That's it. I remember.
Need a second.
I'll second it.
Okay, are we done? Done?
Yep.
Okay, Mr. Short,
Aye.
Mr. Corso,
Aye.
Mr. Santola,
Aye.
Mr. Spampanato,
Aye.
Mrs. Volo. Aye.
All right. Thank you.